Welcome to this installment of the Lexbe eDiscovery webinar series, Protecting Privilege in Document-Intensive Cases. My name is Christian, and I will be introducing our speaker for today's webinar. First, a little bit of information about the webinar series. It takes place monthly. It covers a variety of eDiscovery Hello, welcome to this installment of the Lexbe eDiscovery webinar series, Protecting Privilege in Document-Intensive Cases. My name is Christian, and I will be introducing our speaker for today's webinar. First, a little bit of information about the webinar series. It takes place monthly. It covers a variety of eDiscovery topics, and there's some feedback on what attendees are saying from these webinars. A little about Lexbe, Austin, Texas-based eDiscovery software services provider, specializing in small and medium-sized law firms. And there are a few quotes there. Now on to our speaker, Gene Albert. He's the CEO of Lexbe and a frequent speaker and author on eDiscovery and legal technology issues, a member of the Planning Committee for the Electronic Discovery Institute, State Bar of Texas, an eDiscovery consultant and expert, and you see his education, an MBA from UT and a JD from Southern Methodist. And with that, I will turn things over to Gene.
Great, thank you, Christian, and thank you everybody for attending. I'm excited about giving this talk on privilege. This is a big question that we have from our clients as they're dealing with larger and larger document sets, and they want to know what are the best practices and how to work through doing an effective privilege review in a short period of time. The agenda here, what we'll be covering, will be going over the data growth and why this affects privilege so much, what the general ethical requirements are for attorneys, privilege logging requirements and particularities that we have of certain types of ESI, email most particularly, use of federal evidence 502 orders, clawbacks, and similar things, how to optimize a workflow in a modern litigation review system with automatic logging, how to do better search, what near-dupe analysis is, categorical logging, which I think has got tremendous potential and not that many people know about it, and then we'll close with a checklist of recommendations. One thing I want to say generally about this, how we do these webinars, because this question comes up sometimes, is we, even though we're an eDiscovery vendor and we have our own software, we treat these as being very educational in scope, and sometimes people will occasionally ask about why we didn't get into our software. They were expecting it to be a product demo or something. We don't do that in these. We are happy to give those, and Christian will give the option to that at the end. But we'll use screenshots from our software, of course, to illustrate various points. But these are things that generally can be gotten, with at least some other providers, if not exactly the way we do that. So just a little bit of clarification on that for people as we go through this. Growth in data. What does that mean for privilege claims? We're all used to these really mind-numbing statistics about how data is growing. So here's the latest one is that we're supposed to go from 3 zettabytes, which is a zettabyte is a trillion gigabytes, to 40 worldwide in digital information from 2014 to 2020. What does that mean? I mean, one thing it means is that the data growth is not leveling off. Some people, it's a natural thing to think that, well, it's grown for a while, it's going to level off, and it'll kind of, if not return to the way it was before, it'll at least not keep getting worse. But that's not happening. Data continues to grow at an exponential growth. This other stat I think is really more meaningful to me, and this one's held clear, steady for several years, is that the total amount of data captured and stored by industry doubles every 1.2 years. So that means every year the data in a typical case is doubling, and software needs to, and changes in procedures and review procedures needs to be getting more efficient 100% every year just to keep up, just to tread water. This is because we don't have more time. There's not, we can't expand out how much time discovery takes, and there's not more money. Cases are worth what they're worth, and there's not more money for discovery review or privilege review or eDiscovery vendor costs. So we need to be getting pretty massively more efficient every year. The only way this can really be done is with effective use of technology, along with procedure changes. So this is ongoing. What are the increasing risks and problems in privilege review? Why does this affect privilege review? Well, there's a number of reasons why the data growth, ESI, electronically stored information, means the rubber hits the road with privilege review. One is that there's just more documents to review for privilege. The linear review gets more and more difficult, and you need to be looking at keyword searching or other technology-assisted review. You're possibly using outside reviewers for larger data sets, and they may know less about that and miss things that somebody that more involved would know. There's often many duplicates or near duplicates of privileged documents and some can be caught and others missed, and that's a problem. Heavy use of email and how to handle the strings and with privileged communication, is a knotty problem and more than ever, and how to log that. Let me talk now about just the underlying ethical rules here a little bit for lawyers, and I'll be referring to the ABA rules, although they're typically similar things in the state rules. There's the general requirement that a lawyer will not reveal information, and that the lawyer will make a reasonable effort to prevent inadvertent or unauthorized disclosure. Under 1.6, there's a duty of competence that the lawyer will competently represent, and this has been changed in recent years to not only to keep abreast of changes in the law, but should keep abreast with changes in benefits and risk of using relevant technology. Judges more and more want to see that, and many of us lawyers came in being Luddites, but there's really not a lot of room for that anymore, particularly in the document-intensive cases. The Sedona conference that we'll discuss some of their recommendations. They're very influential, but they make the point that litigants and lawyers should be using information and search and retrieval methods and the best of technology to include the efficiency of the process. There's a duty to expedite litigation as well. That's often forgotten. That's the first rule, Federal Rule of Civil Procedure, is the rule should be interpreted to secure the just, speedy, and inexpensive determination of every action. And the ABA model rule has that the lawyer use reasonable efforts to expedite litigation. And that's really the challenge of technology into the legal system, is that with the growth of documents in ESI, that really puts to a test of how can we stick to that promise of just, speedy, and inexpensive determination of every action. Let me move on to important Federal Rule of Procedure 502A, and this applies to federal, not state. There are other state rules, but the federal rule can apply to state actions that are both in because of diversity jurisdiction, but also if there is any part of the actions in federal court. 502D allows for an order that binds state and federal proceedings. So often it's used in this way. 502D, everybody should be pretty familiar with this because it's very important. It enables the parties to establish discovery protocols, and that these agreements can be integrated into the parties' agreements, but also into court order. and it's very open as to what this can be used for, and it's being used more and more creatively. It can be used for clawback agreements, which we'll discuss, that have been pretty common, but there can be a quick peek privilege log protocols. What is the protocol for privilege review? Categorical logging of privilege, which I'll discuss more. The scope of preservation, phased eDiscovery, electronic discovery, and other matters. These can be part of the parties' agreement, but it's more powerful if it's in a court order, and the courts can also order this sua sponte, and some of them do that. Turning over to the Federal Rules of Civil Procedure, one interesting thing is that with respect to privilege logging, that the rules themselves are not at all specific as to what ought to be in a privilege log, and I think we sometimes think that our standard privilege log of all the fields that we traditionally see are in there are in the rules, but they're not. This is in court practice and also court decisions. And they don't address the basics of what a log ought to be, much less the more complicated issues of how to handle email chains, etc. There are court decisions, many and recent ones, as to what ought to be in that log, and it's the traditional things that we expect of the author data, addressee, copies, why it was withheld, etc. There is there are also court cases and recent ones on use it or lose it, that an incomplete or an improper privilege log can result in waiver, and we continue to see modern cases of this. This can include general conclusory assertions that were privileged without sufficient reasons, but often it's just that a privilege log wasn't actually delivered, and that can result in waiver. And the best practice on that is to deliver that, if not with the production, shortly thereafter, and before the depositions start, and certainly before discovery ends, to avoid claims of prejudice. There are more modern cases that disfavor a waiver as a remedy, but it's still used. Another problem that we have in how to do privilege logging is email chains, and that's can be a fairly complicated issue in how to do that, because there's a couple different types of chains. One part is where you've got separate emails that could be brought together as part of a chain, and that can be complicated because they won't always stay in the same subject matters. People may keep the heading or the subject of a privilege chain or chain of emails in general that might be privileged can wander off of the original topic, sometimes keeping the headers the same. A related issue is where you have emails nested within a single, multiple emails nested within a single email, either as an attachment or just part of the text. And this can vary quite a bit by what email clients things were transferred on, and how to deal with this in the conversations can be complicated. It's good if you have a lot of these issues in a big case. It's good to get out and define a specific protocol that's being followed, and then get that into an ESI order agreement. Absent that, the law is sort of all over the place on how this should be handled. And I'll talk a little bit more about that a little bit later here. And then I think I've really kind of gone over this one with the strings of how to handle that, and it can be in different parts of the email strings or multiple emails. One question of how to deal with this, if you have emails that are partially privileged, is what's the best practice for dealing with this? Should they be split up or separated out, or is the non-privileged information withheld, or how much? One solution that we recommend, that we see more and more of, is that one go in on these mixed email strings, and redact out the privileged portions and then produce the non-privileged portions. And this really isn't subject to much, can't be subject to criticism much, and as a best practice. And the mechanics of this would be to keep a privilege log and then keep a supplemental privilege log by reason of redaction. So you'd have a redaction log that would be looked very much like a privilege log and would say these, we redacted out these privileged portions on these emails, and then you go ahead and deliver the redacted versions of the emails that are now non-privileged because you've redacted out all the privileged or work product information. We talked a little bit about these 502 orders. These are pretty common now that they'll be in ESI agreements or orders. Here's an example of one, some language from one that we have on our Lexbe website, or we can follow up and provide to anybody. We have a sample ESI order that has a number of provisions that would be typical of eDiscovery in production matters, and it's available on our website, or we'd be happy to send it to you. Let me talk a little bit more about the Sedona conference. They have a very helpful delivery that happened last year of commentary and protection of privileged ESI, where they go into quite a bit of detail of their influential opinion of best practices. Among the things they advocate that is not often done, or maybe not done enough, is that the council needs to be prepared to explain and substantiate search and retrieval methodology used in privilege review, including the reasons for specific search choices, who did it and why, and to document the overall process. So this, in their opinion, is not something that can be kept secret. Also to establish quality control measures and to test and verify what was done, and to be able to statistically validate it. That is an important thing to be thinking about, and that whatever one is doing on the privilege log procedure, that be a defensible, documented procedure that you can be prepared to show to a judge if needed to justify how you did your privilege review. Let me jump into a couple specifics, and the screenshots are out of our software of what you would like to see in a privilege review. One in our opinion is just to be able to easily see multiple views of the document. Any document that comes into a modern litigation review system has been processed to varying degrees, and you've got multiple versions of one document. We handle this with our tabbed environment in our document viewer, so there will often be an image view of it, which we do as a text-based PDF. Many other systems will use as a TIFF, that you can see, and this can have a control number, be bait stamped, and this can be redacted. So then you have a redacted version of it. We have text that we pull out of the OCR. You often want to go back and look at the native version of that. We have that with the original, to where you can see what the document was originally, and that's often important with emails. And that we also have an HTML version that we pull off of the text out of the native version. We also have a translated version, where we don't see a tab here, where if you translated the document, you can see the English version as well, and that can be important for maintaining privilege across languages, and also your annotated version if you've done that for depots. More on search and how this would work is, when you're doing search for privilege review, you want to have on the basic just something that's accurate and fully indexed, isn't missing anything. Better is having many different search options, including a Boolean search, as we're used to with Westlaw and LexisNexis, keyword highlighting, fuzzy and stemming search, which will allow for some misspelling or abbreviation, concept search that will include synonyms and things that would come up in the thesaurus, and then the search needs to be very fast. It should be returning in seconds, certainly not minutes, even for larger cases. translations integrated, as I mentioned, and then we do the dual indexing of the natives and OCR or paginated versions that I'll talk a little bit more about. How does the workflow work? Well, you'll identify ones through search, that you want to identify as being privileged or potentially privileged, and you'll do a multi-doc edit or a massive coding. Here it's on the responsive field on the screen cap, but same thing with privilege, so that you can go through and look at a lot of documents and then mark them all at the same time. Another important workflow option is to be able to mark as privilege an entire email chain and putting the attachments at one time. So we do that one in our document viewer, that if you're tagging a document to be for in any field, but attorney privilege and product and work product here, that you can have a persistent option that it automatically also tags all the members of the email family as well, the attachments that have come out of that as well, and then you can do a multi-doc edit update in general on them as well. Wanted to mention a little bit about dual indexing. That's something particular to our software. I haven't heard that anybody else does that. What we do is we put into our search index both the text that we can extract out of the native version of a document and also what we get after creating a PDF and doing an OCR. And this, surprisingly to some that haven't worked in this before, can provide very different results, because the image version, whenever that's being done to a PDF or TIFF, that's going to be what would come out if you were to print the document. It's a virtual print, where the native extraction will pull what is in the native version of it, and those will have some significant differences. There can be many things that can be excluded from print, such as hidden tabs or rows or white text or just a number of things that wouldn't show up in a print or virtual print of a document, that will be picked up with the native extraction. The native extraction, though, doesn't get anything that would benefit from OCR, optical character recognition. So the printed version, the virtual printed version, will take any images that are the documents themselves, or they were scanned or otherwise made into an image, or embedded images, and convert those to text with OCR, which the native version doesn't get. You're trading that off whenever if you pick one or the other. What we do is we concatenate, join them both into the search index to get the benefit of both. Another important thing of a modern eDiscovery system will be automatic privilege logging, and here this takes the metadata from the natives, and these are automatically fielded into the system, into the database. So the important standard privilege log fields, the document date, who's it from, who's it to, what's the subject matter, etc., will be pulled out and put into metadata coding. And then an automatic privilege log that, subject to further editing by the litigation team, is generated, and that greatly speeds things up for getting a privilege log. And here's some screenshots of how that looks in our system. Let me go over some other issues of how to deal with some of the problems and what the solutions are for dealing with privilege. One of them is how to deal with email change, because that is not at all very clear what should be done under federal law. The best description of how to do this is under New York law. They've got a state rule 11B that specifically addresses how email change should be done, and they have a presumption that each email chain it constitutes a single entry in the log. And there's some requirements on that you show that it's an uninterrupted dialogue, not that you haven't had a wandering or divergence of the subject matter of it through the email chain, or it should be broken up. Beginning and ending dates of the time to the dialogue across all the emails, the number of emails in the dialogue, the names of all authors and recipients, and information sufficient to identify each person. So the entire conversation is is brought up into a single discussion in New York. Now, this is not in federal law, so to implement this, there'd need to be agreement of the parties under 502 in federal court. Another provision that has been a related way of dealing with privilege in general is to have categorical logs, and I think this is greatly underutilized. And the idea is that instead of breaking out each individual one, certain types of privilege documents are brought up into categories and summarized, and that is the initial disclosure for the privilege log. And then if they need to be, if one needs to delve into the details of that, then that is dealt with on a case-by-case basis rather than logging everything. And this can make a lot of sense. This is not in the federal rules right now, but it's suggested, and it has been developed in New York again. And I'll show an example one. So it's actually been mentioned in the Federal Rules of Civil Procedure as a suggestion since '93 that a lot of people don't know about, to be used when privilege log would otherwise be unduly burdensome. The Sonoma Conference recommends it as well, and New York details it as mentioned. What are one of these things? What's included in one of these categorical privilege logs, and what does one look like? Well, the fields under New York, as it suggests, would be the date range, the document type, sender receiver, the category description, privilege, and total documents. What are examples of some of these categories? Well, communication with outside counsel or inside counsel, and with the latter specifying that it had to do with specific legal advice. Work product, communications in anticipation of litigation. And here's an example, and this is just taken from a New York, one done in New York as an example. And you can see how the categories are that in this one, instead of identifying 415 separate documents, including attachments from the email families, or 325 emails, at the family level, that it's all one entry in the log showing the overall date range, the senders, receivers, copies, and the overall detail of the communication. So this would greatly lessen what was done. And again, this would need to be done by agreement under federal court, or court could issue that sua sponte as well. Let me move on to near duplicate detection and talk about that a little bit. Near duplicate detection is a technology to find documents that are similar but not exact copies of other documents. And by exact copies here, I mean ones that could be hashed using an exact digital signature that we use an MD5 code that requires that it be exactly the same electronic document would be the exact document. There are many that are very similar to being the exact documents or close to them that could be revisions but also separately scanned, or ones that went through different email systems or something could not show up as an exact duplicate but be a near duplicate and through a text comparison methodology. And I'm not going into all the detail of how this is done here because of time, but we'd be happy to explain it more. But what this allows you to do is find documents that are similar to each other, that are at least 50% the same. This has a here on our, again, out of our platform, this is showing a document, and then it's showing on the right the similar versions of the privilege documents that might want to be reviewed as well and marked privilege. And the advantage of this is to pick up ones that have where one might have found many versions of a privileged document, but not all of them. So one or more of them get out, even though a lot of them were retained. And this happens all the time, as we hear. So then what the near dupe review allows you to do is to identify some of your documents as privileged and then find the other ones that are very similar to them and look for them for privilege review. That is excellent way of catching things that might otherwise have gotten through. Then one runs a report, that shows some of the near-dupe group and see if they have been consistently marked as responsive privileged work product confidential. So here's an example where 9 versions of the document were found, but 1 was missed. And in a real case that something like that could get out and be very damaging, even with a clawback agreement. You've still let the horse out of the barn, as they say, and it can be detrimental to one's case. Another point I wanted to mention with privilege is watching out for redaction traps. Often, documents will need to be redacted to take privilege out, and as part of doing that, one needs to be careful to make sure that the system that you're using has proper logic to make sure that the unredacted version hasn't made it into the production, and also that the related natives have been pulled back out. So if you are delivering natives as part of your production, that native document and any container files, which would be ones were part of that native including MSGs from emails or zips or other files like that, have also been withheld. And dual indexing can help catch that, but one needs to build in time for QC procedures and then be pretty confident in the software that you're using in larger document cases if everything isn't being individually looked at. But there have been certainly a lot of redaction errors that have been made in the industry over the years, some very famous ones. So that's an issue to look at in these privilege reviews. I'm going to finish up here with a checklist of recommendations in protecting privilege. Communicate with opposing counsel early and document your efforts. I think being Rule 26, meet and confer. Negotiate 502 orders and agreements and clawbacks to avoid inadvertent waiver. Make use of a modern eDiscovery review tool, ours or others. This is going to give you a quality search, fast indexing, auto privilege logging, redaction, privilege logic. Determine if categorical logging can or should be done in this case. This can really limit the requirements. Deliver a log contemporaneous with your production, or soon thereafter, as there can be issues of waiver if you don't do that. Consider redaction of email strings and attachments as a way of dealing with mixed email groupings. Allow extra time for production QC, particularly looking at redactions and natives and production logic. Negotiate specific provisions of everything you're doing in ESI orders. If possible, this really helps keep costs down and move things along quickly. And then consider using near duplicate technology as a safeguard or double check if appropriate in larger cases. I want to thank everybody for attending with this. Please give us feedback on both this webinar and also what you'd like to see in the future. We have a short 1-minute survey after we'd love hearing you from. And I will turn things back over to Christian. Thank you.
Thank you, Gene. That was really informative. That was great. And thank you again, everybody, for attending. Here in the following days after this, we're going to be making available a recorded streaming version of the webinar, an MP3 podcast version, and the webinar slide deck. So if anybody wants that, it's going to be available soon. Please let us know if you have questions or comments on the webinar or this topic or anything you want to see in the future webinars, and you can contact myself or Gene directly if you have questions about the material or the webinar series here or anything you saw today. Today in the webinar, we did show some stuff from the Lexbe platform, but this webinar is mostly informative. It doesn't really cover software, and so if you want to see the software, please contact myself, contact Gene, and we'd be happy to show you the software more in depth. If you want to ask us more about the platform, here are just a few quotes from some reviewers about the platform, and as I said, we'd be happy to show it to you. And thanks again, everybody, for attending, and have a great rest of your day.